Good morning, everyone. I'd like to welcome you to today's program, Trade Secrets and Cybersecurity, issue for today's businesses. My name is Jennifer McAleer, and I'm a partner in the litigation department at Fasken, and I will be the moderator for today's program. We think today's program is very timely given the COVID-19 situation and the fact that most businesses now have employees, sometimes 100% of their employees, working from home. Most large and small employers were, in our view, not ready 100% for people working from home. And traditionally, the protection around infrastructure has been focused on the stationary infrastructure, the bricks and mortar. And now, with everybody working from home, obviously that focus has had to shift. Organizations need to be stronger. They need more protection for infrastructure that is now more online than bricks and mortar. People are working at home more, and in doing so, becoming, in our experience, a little bit less cautious, less motivated, and perhaps more apt to click links that are being sent to them, even though they may know that that's not wise. The reality is also that there's an awful lot more data in motion than there had been pre-COVID. We've also seen a lot of people moving at unprecedented levels from one employer to the next. So all of this raises some issues that our panelists are going to discuss today, in particular in the context of protecting trade secrets. And we're going to try and end our discussion today looking at some hypothetical fact scenarios and try and give you as much practical advice as we can on how to deal with these issues as they come up. So we have a very experienced panel today. I'm going to introduce people in the order in which they are going to speak. So first, we will hear from Jason Markwell. Jason is an intellectual property lawyer. He works on cases involving trade secrets, and he will explain how they intersect with other forms of intellectual property. Next, we'll have Alix Herber. Alix is a labor and employment lawyer and has been practicing in the area for over 20 years. She deals with all aspects of the employment relationship, including non-disclosure agreements and restrictive covenants. Next, we'll have Berkley Sells. Berkley is a colleague of mine in the litigation department. He's been counsel in many important court cases involving trade secrets and related issues for more than 20 years, with a special focus on urgent injunctions and other extraordinary remedies. And finally, and interspersed within the discussion, we will hear from Joe Coltson. And Joe is a partner at PwC. He leads the firm's cyber forensic investigation practice. And Joe is a former law enforcement officer with over 30 years of investigation experience and cybersecurity experience. So with that, I will ask that we start. These are just some introductory slides about PowerPoint, which I won't read. We can flip on to the next one, please. Everybody has their trade secrets. Next slide, please. All right, Jason, could you start us off in the discussion, please?
Thanks, Jennifer. I was hoping you would go through the PowerPoint slide because I think we can all agree that after 15 months of working from home and speaking to each other virtually, we've all become far too familiar with PowerPoint and other virtual technologies, which some of them can be quite, searching for the right word, but I think you know what I mean. What I would say is that as a result of working from home, we are exchanging a lot more information virtually. A number of white-collar jobs are being performed in this manner. Emails are flowing everywhere. The danger of disclosing confidential information becomes far more manifest in this situation. It's gone are the days when you could lock things in filing cabinets and be sure that everything was locked out nicely. Next slide. So what I'm going to talk about today is basically what is a trade secret and how does it fit with other forms of intellectual property. All of this will be a foundation for the broader discussion that Alix, Joe, and Berkley will have in specific scenarios. At its highest, a trade secret is an example of intellectual property. Intellectual property is one of those terms that you hear a lot, but it doesn't really have a clear definition. What I would say generally is it is the result of something creative. That creativity could be coming up with a new chemical compound, or it could be writing a great work of fiction, or it could be coming up with a fantastic trade name like Xerox that is used as a trademark. Or it could be the shape of something that is protected as an industrial design. But what I'm going to talk about today is trade secrets. And what differentiates trade secrets from other types of intellectual property is that they get their value from being kept secret, whereas other forms of intellectual property get their value from being made public. So when you file a patent application, you disclose to the world your invention, and you tell them exactly what it is you've invented, how it works, and how somebody else can put it into practice when the patent monopoly ends. And likewise, the whole premise of a trademark is that you are going to market using this particular word or phrase or picture in association with your products. And likewise, a copyright is the fixed expression of an idea. It's a book, it's a movie, it's a video. It's inherently public. What differentiates a trade secret is that nobody knows about them. They are things that businesses keep very confidential and deliberately try to make sure that they are not disclosed. And the paradigm example, of course, is the formula to make Coca-Cola, which has been guarded for over 100 years. Only a handful of people know about it. It's not known widely. You can't go onto the Coca-Cola website and figure it out. Likewise, Kentucky Fried Chicken. They always brag about their 7 herbs and spices. Nobody knows what they are. Again, you can't find a public source of that information. So the value resides in the fact that it's secret, people don't know about it, and that you do everything in your power to keep it confidential. Here are some examples of trade secrets. I won't read them all out loud, but you can see that they are broad. They can exist in almost every form of business. And I've just sort of done a little bit of brainstorming before the call. And I thought about the recipes that we spoke of a moment ago and the formula to make Coca-Cola and the 7 herbs and spices. But they also exist, and you'll have seen a lot of this in the media recently with COVID-19 vaccines, where the structure of the antibody is known, the antigen is known, there are patent applications filed for those things, there are trademarks covering the names of the vaccines, there are product monographs that are the product of copyright, et cetera, et cetera. But the reason that they have such value, and we hear about this in terms of compulsory licensing to third world countries, is that the way that you make them, how you scale up the process, the cell culture times, all of those things are not public information. They are the know-how that allow those companies to produce those vaccines. Similarly, those kinds of trade secrets can exist outside of the pharmaceutical realm in the financial services industry. For instance, trading algorithms that are used by investment banks. How do you know, how can you model prices going up and down? You won't find all of that sort of stuff published anywhere in the internet. And then finally, how does Netflix know what I might like to watch next? It knows that because it's watched what I've seen. It's kept track of what I've watched before. Or how does Twitter know people I might like to follow? None of that is protected by a patent. All of that is based on internal know-how. And you won't, I haven't done an analysis, but if I would assume, you couldn't go into those businesses and find it posted on their bulletin board in the front hall. This is information that they keep very strictly guarded. Trade secrets also are different from other forms of intellectual property, at least in Canada, in that there is no federal or provincial statute that protects them. Unlike a patent or a trademark or a copyright where there's federal and provincial legislation in some instances that create rights and enforcement tools, there's nothing like that with respect to trade secrets. Instead, what we rely on is the so-called common law. You go to court, you explain that you had a contract and that somebody breached it, and as a result, your secrets ended up in the public domain. Or an employee walks out the door carrying a briefcase full of stuff that they shouldn't have. That's when Alix and Berkley get involved. What I would say is that there is now some governing legislation under the criminal code. The government has the right to prosecute people if they do something intentionally that causes harm to individuals. It's early days for that, and we don't really know how all of that's going to shake down, but at least there is now a criminal remedy if somebody really goes offside. And of course, under international law, there's the United States, Mexico, Canada trade agreement. There's the WIPO TRIPS type agreements that require all member countries, and Canada is a member country, as is the United States and all of the European entities, to create remedies to protect trade secrets, among other forms of intellectual property. So what are the advantages of a trade secret? The advantages are all you have to do is keep the information secret. You don't have to file an application with anybody. You don't have to pay fees to maintain your registrations, and they are valid for as long as you can keep the secret. If Coke manages to keep that formula secret for the next 1,000 years, then it will continue to be a trade secret. Also, there are no territorial limitations. If somebody were to make a copycat version of Coke using the trade secret information in Indonesia, that would be equally actionable as if it were to happen in Atlanta. The disadvantages are that when you assert a trade secret, you have to establish that the information is confidential. And it's very difficult to do that sometimes. You have to establish the steps you've taken to keep this secret. You can't just say that it was a secret. You have to say, here's my safe. Here are the encryption tools I've used. Here are the people who knew about it. Nobody knew everything. Only some people knew certain pieces, and they had to piece them together, et cetera, et cetera. That makes them sometimes difficult to prove and enforce. Berkley can elaborate on that. And of course, there's no statutory remedy. Unlike a copyright or a trademark, you can't just go to a court and say, wave a trademark around in your hand and explain how it's been infringed. It's more nuanced than that. With that, I'm going to turn the microphone over to my partner, Alix.
Thanks, Jason. So welcome, everyone. I'm going to be talking today about how do we protect trade secrets or confidential information in our businesses from an employment perspective. You know, trade secrets is really a term that's really confidential information and how we use the confidential information in our business. So in terms of the sort of legal framework around these obligations, as Jason mentioned earlier, the common law, which is what you enforce through the court system, has obligations as they apply to confidential information. And this is where you do not have a written contract, or you do have a written contract that doesn't specifically deal with confidential or trade secret information. And so you have these obligations under law and under the common law. And the first is the duty of good faith and fidelity. And the second is breach of confidence. Next slide, please. In terms of the duty of good faith and fidelity, obviously this obligation employees have is to serve their employer honestly and faithfully and act in the best interests of their employer. And this obligation applies whether or not they have a written contract, regardless of whether they're a fiduciary. And when we look at the term fiduciary, we're really looking at people in senior positions who are directors or senior directors, your executive level people who would be privy to information at a much higher level and would be considered a fiduciary obligation. And they have additional obligations under the common law, which we won't focus on today, but those are obviously not to solicit or take corporate advantage if they leave your employee to go to a competitor. And obviously this duty also applies during the employment term and after the employment ends. Can we go to the next slide? Thank you. So in terms of breach of confidence, really a breach of confidence is a claim to protect confidential information. And this is information that was conveyed as being confidential, it was communicated in confidence, and then the confidential information was misused. And generally what we'll see is courts will restrain employees from publishing or divulging confidential information that was communicated in confidence, where that person was told not to divulge that information, and they then make improper use of it. Now, in some situations, for those of you here who may operate in the US, there are claims in the US called the claim of inevitable disclosure, which means that it's impossible for the employee to perform their duties without somehow disclosing the information of their former employer's trade secrets, and therefore it's inevitable that that disclosure will happen and cause injury to their former employer. This type of claim has been actively rejected in Canada as you require actual evidence of the disclosure in order for the employer to establish a breach of confidence. So obviously, where there exist these obligations, you can't, in my view, on a practical level, rely on employees to just know that they have these obligations of good faith and obviously of confidence. And so it's really important as an employer to make sure employees understand what is confidential information and how they should be using it in the context of their employment. And so it's very common, and most of my clients have this, is to obviously put into effect confidentiality agreements or to include them in the employment letters and agreements, or in fact, as part of your restrictive covenant agreements. And these will, for the most part, codify these common law obligations. When you think about entering into confidential information agreements, it's really important to think about when you do it. So I have clients who'll say, oh, I hired this new person and then they started and then I wanted them to sign this confidential agreement. And you're really taking a risk when you're not ensuring that at the time of hire, the employer is aware of the obligation, is given a copy of that confidential agreement, has the opportunity to review it, understands that it's a condition and term of their employment that they adhere to the obligations set out in that agreement, and that they sign that agreement before they actually start employment with you. And this ensures that you have appropriate consideration. And I say that because most of the time my clients will include the confidentiality and non-disclosure obligations as part of their as part of an agreement that also includes non-solicitation obligations, and in rare cases, non-competition covenants. And that's because if there's no consideration given at the time that the employee signs the agreement, you risk having a court not enforce those obligations. So really important to think about when you're getting that confidential agreement to the employee. The other thing that sometimes happens is we obviously use template agreements sometimes and a one-size-fits-all approach, which doesn't always work based on your business. So and also on the role of the employee. So sometimes it's really important to think about what is in that agreement, whether it relates to your business, the nature of your business, and to the employee's role within your business. So defining confidential information. When we draft confidential agreements, sometimes we can take confidential definitions off the internet, and they are very, broadly drafted, which can be good in some situations. But it's really important to think about your business and the type of information that you're looking to protect. So if you're very much concerned about your client or customer information, to make sure you draw that you set that out in the confidential information definition. Make sure that it covers any intellectual property that the employee may create, and be specific enough that the employee understands what's being protected. Because we always want to go back to the basics, which is employees need to be able to read these agreements and really understand what information they're going to be privy to, and what they need to be careful about how they use it and disclose it to third parties. So obviously you want to set out the nature of your business and why it's important that that information is being protected. Sometimes I find it's also useful to provide specific examples, and that can be included in the agreement or in your policies, which I'll get to in a minute. But then the second thing you want to set out is what are the obligations. Sometimes when I see drafts of my client, they only protect certain parts of the confidential information. So they'll say, let's keep the information confidential. But you also want to make sure it also prohibits the disclosure to third parties, that it sets out that they're only to use that confidential information for purposes of their employment, and that's expressly authorized to be used, and that you've taken active steps to protect your confidential information. I also think it's important to add into your confidentiality agreements that they have an obligation to notify the employer of any suspected unauthorized use of confidential information. And these can obviously survive the termination of that employee's employment, regardless of the reason why they may be terminated. And finally, as I've mentioned before, it's important to look at what other restricted covenants may be required based on the nature of your business. Now, non-solicitation provisions are often used in conjunction with confidentiality obligations, and that's because you also want to make sure that employees, when they leave, do not solicit your clients or customers or your existing employees or consultants. And it's important when you put these covenants in to recognize that, the law is constantly evolving, and obligations that you put in around non-solicitation have to be reasonable in scope. So you want to have a severability clause to make sure that if those non-solicitation provisions don't operate to protect your business, or in fact your non-competition covenants, which, as we know, Canadian courts generally don't like to enforce if they think the non-solicitation provisions are adequate or sufficient to protect your business, then you want to make sure you have well-drafted confidentiality covenants so that you ensure that you're protecting your information at the very least.
So Alix, just before you move on, there's a question that came in that I think I'll put to you at this point. So one of the questions is, well, let's assume for a minute you don't have a confidentiality agreement, but you make it clear either in a conversation or in an email that the information that's being provided is to be treated as confidential information. And I suspect your answer may differ. If it's just a conversation, then we get into a contest as to
what exactly was communicated. Exactly.
Right. If it's an email, at least there's a record. But what are your views on that? And does that give an employer the kind of security they need?
Well, I always believe that, you want to have layers of security for your employees. So, having a confidential agreement is the best way to articulate those covenants and what the expectations are. That can be reinforced by your actual policies that you have in your organization around confidential information. And certainly if there's particular information that's quite sensitive to the business, reinforcing that through an email or through some written communication is really important. Having a verbal discussion with an employee is going to be hard to remember exactly what was communicated at the time. And the employee can therefore also say, I didn't understand it in the way that you may have thought you communicated it. It creates ambiguity in what those agreements were and what you actually communicated around the confidential information. So again, that leads perfectly into sort of some of the language that we use here to ensure that, confidential information is expressly set out, right? And as you can see in this definition, we even put in here whether or not such information is marked confidential. Like, you don't actually have to mark the information as confidential in order for it to be confidential. But again, it's important to do that on a practical level wherever you can. So you're always reinforcing to your employees that the information is confidential. We obviously have seen an evolution of, how employees use information and how much information is being used by employees, especially in this pandemic. And so it's not unusual in my experience with what my clients are telling me that people get lazy or not always aware of the information that they may be using, especially in their home context. So reinforcing information is confidential, using, putting confidential on the document can reinforce that to employees on a regular basis. And that leads perfectly, Jen, into the next slide, which is how do we safeguard our confidential information? And so obviously, policies are another great way to do it, where you can specifically include nuances to around, the fact that confidential information, here are some examples of confidential information. You want to make sure that it's consistent with any agreement you may have in force. But what's most important, and this is where sometimes I see some of my clients having issues, which is you have a perfectly drafted confidential information policy and it's put in your employee handbook, but you have no way of actually confirming that you've drawn the employee's attention to that policy, especially when it's part of an employee handbook, which has, maybe 50 or 60 other pages of policies around their employment terms. You're not necessarily drawing the employee's attention to that confidential information policy. So I always think it's good to have, reinforce that through training if at all possible, but certainly make sure that employees acknowledge those policies and sign off on it. That's another good way that if they breach those obligations post-employment, you can prove to the court that the employee was aware that information was confidential, they signed off on it, and you even mark the information as confidential. So all those basically help in safeguarding your business confidential information. And then obviously, and I know Joe will jump onto this, and maybe Joe wants to jump onto that now, but to talk about the additional security measures, especially around the use of electronic security measures. And that's because obviously, when we're all working remotely and people all have their devices in different locations and maybe going to cottages or other people's homes, especially over the summer, we may be out of this lockdown for a brief period of time. You want to make sure that you're protecting your information through passwords, through adequate security measures on your devices. Joe, not sure if you want to jump in on that now.
Yeah, sure. Thanks, Alix. Certainly from a safeguarding standpoint, from a cybersecurity lens, you want to make sure that your confidential information, whether it's personally identifiable information, whether it's intellectual property, what have you, is part of your, in security terms, part of your crown jewels, has been identified as such and is protected as such. Oftentimes what we see is clients will take the extra step of getting a good feel for where their data is located, having a good, for lack of a better word, index of where their data is located, and just making sure that you're protecting those sections of your environment. So identification is key.
And I would add in a couple things that I've noticed with some of my clients who are sort of subsidiaries of US clients. I've seen a move in some ways in the US that allows employees to use their own personal devices for work purposes, and that is something that you really want to be careful about because they're actually then having information on their personal devices. So Joe, I don't know if you've experienced some of that as well.
Yeah, for sure. You lose, an organization loses a little bit of control around a bring your own device environment. If you look at sort of the world that we live in now with the vast majority of folks working remotely, the cyber resilience of an organization is stretched thin. Adding something like a bring your own device policy and environment to that just adds fuel to the fire to an extent. I often find that organizations do lose some valuable control in a bring your own device environment. So it's a situation where you really need to be mindful of that loss of control and be mindful of the fact that you're commingling personal data with professional data.
Exactly. So when you think about all of these things, the other thing that some of my clients have done is not allow information on their company owned devices to have access to drives or USB ports to ensure that you can't download that information onto a separate portable device. So not sure if you've seen that, Joe.
Yeah, and printing's a big one as well, to make sure that you're not allowing printing from home and that sort of thing.
So, as a final point before I move on to my last slide, I think it's one of those things where sometimes my clients will put in these safeguards, either, with confidential agreements and policies, and then, not reinforce it on a regular basis. So I always remind clients it's always important to reinforce what information is confidential, to remind employees of their obligations of confidentiality. Some of my clients, what they do it is on an annual basis, is to send out a reminder with the attachment to the confidential information policy to reinforce people's understanding and to remind them of those obligations, because sometimes people just forget it with the sort of day-to-day happenings of their work and not always thinking about it in terms of protecting the information. So another reminder to those of you online today, just to reinforce those obligations. And then, obviously where we'll lead into some of the issues that Berkley and I deal with is around the end of the employment relationship. And so, as a natural, first step, sometimes when employees are terminated, obviously when I drop my termination letters, I ensure that I put in there a reminder that they are to keep the confidential information of the company confidential and not disclose it to any third party. So, that's fine. But what happens when people resign? Resignations are also important to make sure that you're reminding employees of their ongoing obligations of confidentiality, as well as maybe non-solicitation obligations that you may have in your agreements, and to remind them of that when they're leaving. And sometimes we also recommend providing copies of the agreements and the policies that were signed so that they are constantly reminded that they have these contractual and ongoing fiduciary or non-fiduciary obligations to keep the information confidential. Lots of my clients conduct exit interviews, which again also give an opportunity for you to reinforce the confidential obligations that exist for that employee that exists continuing after employment. One interesting thing I see in the agreements that come from the US is sometimes obligations are only kept confidential for like a 2-year period. And in my view, we should be keeping that information confidential for as long as it is not in the public forum. So again, a reminder that you don't need to limit it to a 2-year period, but really ensure that they know that going forward, they're not to disclose any information that's confidential. Obviously, you want to remove the employee's access to the electronic information and ensure the return of your company property. And so obviously, once we leave, then people sometimes don't follow these obligations, which is when I get Berkley involved, so we can continue to assist our clients in restraining the use of confidential information where employees are not abiding by their obligations. Thanks, Jennifer. Over to Berkley.
Thanks, Alex. I'm going to provide some comments on remedies. All of the good advice Alex has just given you, you've followed, and unfortunately you still have a problem. But before I go into that, a question that's come from the audience about the enforceability and utility of standard form email confidentiality notices and whether there's any value to that. So I think we've probably all seen the bottom of the email, part of your almost auto signature says, contents of this email are confidential, please don't forward it, please don't do anything to it. And the question from the audience is, what's the utility of that? And I'll give the usual litigator answer, which is, it depends. Now let me explain what it depends on. So putting magic words on things doesn't change their underlying character. So by way of example, stamping something privileged doesn't make it privileged. Stamping something without prejudice doesn't make it subject to without prejudice privilege. Stamping something confidential, just because you got the stamp, and nobody uses hard copy stamps anymore, but just because you've magically said all your emails are confidential doesn't make them confidential. Go back to the comments Jason provided. But that said, there is still a utility to that confidentiality thing, and I will sometimes manually type the words privileged and confidential. Notwithstanding my email, at the bottom has the auto privileged and confidential. The reason it may help is that if the document and the content of the email is indeed confidential, then the fact that it's marked as such is helpful. So is it determinative? No, unfortunately it's not. And sprinkling magic words doesn't magically alter it. But if it is confidential, then it helps to have that reminder or that evidentiary note that it was indeed conveyed in confidence. Perhaps that's undermined a bit if every email you send, ready for lunch, shall we go for lunch now? Can I move our 1 o'clock to 2 o'clock? If those are all just auto-labeled confidential, it may diminish the value of that, but it's of some utility. I hope that answers the question. If not, ask it differently or give me some more context. So let me turn to my slides. In reflecting on this presentation last night, I took my mind back. I think the first trade secret confidential information injunction I did was almost 23 years ago to the day, and it involved a departing employee printing on a dot matrix printer a large volume of confidential information. That's not how confidential information now gets misused. He couldn't email it to himself because although email existed that long ago, it was not in common use and he didn't have an email. That's not how trade secrets disputes arise anymore. That said, there's still some common themes, and I'm going to try and provide you with some of those. And my focus is going to be on remedies. Like, how do you fix this? You've followed the good advice that you've been provided. You've done what Joe has suggested. You've done what Alex has suggested, and you still have a problem. How do we fix the problem? And so my initial comments are on sources and types of breach. Well, why do you care? This isn't about the taxonomy of breaches, but my suggestion to you is the source of the breach and the type of the breach typically informs the remedy. So if we think of sources of a breach of confidence or sources of a misuse of trade secrets, I'll suggest to you there's really three, but they're not watertight compartments. And one is employees. Alix has gone into this in depth. That's both departing employees, the person who's leaving today, leaving tomorrow. It's disloyal current employees. You've got a problem internally, you don't even know who it is. And it's often former employees. They may have been gone for some period of time, and whether they have old information, which is still confidential, or they're disgruntled, dishonest, disloyal, and they may have a malicious motive. You could regard all of those, what I've called the employee bucket, as internal threats, internal risks. The second bucket is external threats. That is phishing, spear phishing, hackers, hacktivists. And by that, I mean people who may not be motivated by a profit motive. They're not after a Bitcoin ransom. They're after some political or other motivation. That can be a source of external threat to your confidential information. Increasingly, unfortunately, state-sponsored or state-supported actors, and Joe can comment on this as well. And then the final and an interesting and difficult and somewhat rewarding one are anonymous. You don't know. You don't know if it's an internal threat, an external threat. It's anonymous. Your confidential information is suddenly posted on social media. You don't know who did it. And so I'll comment on how do you track what we call track down John Doe. Right? You've got an anonymous breach. Those are very satisfying because if you're successful, and I'm not guaranteeing you success, if you're successful, often the only defense is, I didn't think I'd get caught. And so if you can put somebody behind the keyboard, that type of breach is almost a unique category. And then moving from sources of breach to types of breach, there's really two. One is disclosure, right? So your confidential information is being disclosed. It's therefore lost its value, and your secrets, whatever they are now in the public realm, or at least are with a competitor. The other is misuse. The disclosure, often the motive is malicious. It's just to cause harm. It's just to get your secrets out in the public. They're not making a dollar from that. In contrast, the misuse is usually motivated by profit and typically is in a competitive context. So improper solicitation, improper competition. So why do these sources and types of breach matter? I'd suggest to you they matter because they inform the remedy, right? So what do you want to do? And for example, if it's an ex-employee, that ex-employee in all likelihood is not good for a multi-million-dollar damage award. Okay, so that informs what remedy you're after. Similarly, and I'm not suggesting there's anything wrong with this, but there are times where the client's objective is to identify the source. It's an employee. The remedy is to terminate the employee and do so quietly. You don't want public litigation. You don't want the embarrassment of how this has been handled. And there may be breach notification obligations. If it's an external hack, you may have contracts that say you must tell me if I, as your customer, if my information, and this can be a business to business or a consumer, you may have obligations to notify. Well, if we can solve this problem quietly, confidentially, and within the four corners, maybe we don't have to have the adverse publicity, and we don't have to have expensive litigation in the courts. There's nothing wrong with that. I'm a litigation lawyer. I like going to court. But, there are, what's the source of the breach? What's the remedy I want? The other reality in the anonymous ones, you may never track down John Doe. Or the IP you're trying to compel may be in a foreign country. I'm not going to pick on China unduly, but a Chinese ISP is unlikely to comply with an Ontario Superior Court of Justice order. That's just a reality. So you may hit a brick wall, either for legal reasons or for what I'll call technical reasons, right? The trail may go cold. Similarly, though, you may have a whack-a-mole situation. So getting it off source site A, just to have it pop up in site B, C, D, and E, your remedy is not effective if you're playing whack-a-mole, right? So my suggestion to you is understanding and reflecting on the source and the nature of the breach, and you may have flawed or limited information, informs your remedy. So the remedies are things like get it back, make it stop, or money. So if we could turn to the next slide, please, Nick. So the first three of these injunctions, an Anton Pillar order is akin to a civil search warrant. It's doctrinally and legally, you didn't hear from me that it's like a search warrant. It's not. But when the knock on the door comes and there's a crowd of people in your door saying, hi, we have a court order compelling you to allow us to search your home or your business, your devices are going to be imaged, you have to give us the passwords. That looks and feels and smells an awful lot like a search warrant. It's not, but it's somewhat akin to that. A Mareva, which is an asset freezing order. I had a case where the defendant found out we had frozen all of his assets by trying to buy gas at the gas station, and of course your bank card and your credit cards don't work. Well, that's a Mareva. The assets are frozen. Both of those are extraordinary remedies, and I'll comment on them in more detail on another slide. Norwich orders. Norwich is a very powerful remedy in this area we're talking about, trade secrets. Norwich order is really a disclosure order. And it involves having not a mere witness, but someone who's involved, but not the defendant, give you information. So that could be, and the classic examples are the website host, right? So Facebook or YouTube, they're not your real defendant, but they may be able to give you the IP address of the poster or the internet service provider who it went through. I'm not going to get into the technicalities, but the ISP may, not voluntarily, typically with a consent order or an unopposed court order, that ISP may give you information. So these are powerful disclosure orders so that you can track John Doe, so that you can find where'd the money go, where's the bank account that I now want a Mareva. They're powerful orders that allow you to find the source of your problem so that you can then get an effective remedy against that defendant or defendants. The next one, replevant, that's just a fancy way of saying recovery of property. Picking up on a comment Joe and Alix made about bring your own device, replevant's great if I'm trying to get back my laptop. I'm trying to get back my hard drive. I'm trying to get back the USB that's got my source code. Replevant doesn't work where it's bring your own device. I may be able to image that device. I may be able to Anton Pillar it and say, it's your laptop. You can keep the laptop, but I want a good forensic image of everything that's on it because I think I'm going to find my missing trade secrets on it. And then finally, damages, which are the classic remedy in our system for any sort of harm, including misuse of trade secrets or confidential information. Disgorgement is a fancy way of saying the other side made $1 million. I want that million. In contrast, they may only have made $100,000, but you lost $1 million. So you want your loss of profits. And our system is sophisticated enough and understands, in the Supreme Court Canada case, it's called FBI and Cadbury Schweppes, that the advantage of misuse of confidential information may be a springboard. So your competitor may have gotten, by knowing your secrets that you spent a year working on, they get a springboard to an enhanced and unfair level of competition. They're now 3 months ahead of you, or they're able to catch up with you 3 months faster. Well, that is a class of damages. The final comment I'll give you, and this arises from an unfortunate case I had a number of years ago. You as the plaintiff, your damages may well, for the misuse or loss of your trade secrets, may be far, far in excess of the profit the defendant made. And the analogy I gave once to a judge in the context of this case was somebody selling tickets to deface the Mona Lisa. They may only make $100. They sold 100 tickets for $1, but they defaced your Mona Lisa, right? What Joe was calling the crown jewels, well, they're ruined. So I don't want the $100 that he made by selling those. I need the millions. And realistically, the defendant may not be good for those millions. By the way, in that case, we got an order that the judgment survives bankruptcy. So the person couldn't simply say, oh, well, I'm not good for it. So that gentleman was not very happy with me and pointed out that his life and career was effectively over in Canada because no matter how long or hard he worked, he would never be able to satisfy the judgment. That's a satisfying remedy, but it doesn't solve your problem. The next slide, please. So classic remedy for misuse of confidential information is an injunction. And the reason for that is someone using or disclosing your confidential information, what's that worth? The harm is really irreparable. You can't repair it, and it's very hard to measure or quantify. So the reality, and I don't want to stray into Alix's area, but a mere non-competition covenant, you're going to have a hard time enforcing that. It's probably unenforceable. Even a non-solicitation covenant can be very difficult. So the first step, not giving away Fasken's trade secrets, but my recommendation to anybody, step one, do a good, independent computer forensic review. Hire Joe or somebody on his team or somebody like Joe. Let's get our arms around our evidence. Let's make this case about the theft of our trade secrets. It's not about the questionably enforceable non-comp or the questionably enforceable non-solicit. It's about the defendant took this, Your Honor. It's my secrets. Here's how he or she took it. Here's what it seems they're doing with it. That's a totally different case than saying, well, I'd really like him not to work in my industry for a couple of years. And then in the context of both that type of injunctions generally, there's two types. A prohibitive injunction is stop it. You are not to use my confidential information. You are not to solicit a specified list of customers. The other type of injunction is what we call a mandatory order. You must do something. You must give me that USB back. You must return the source code to me. Mandatory order, I won't bore you with the legalities of it. Mandatory order is typically more difficult. It's typically harder to force someone to do something they don't want to do rather than to stop them from doing something that they arguably shouldn't be able to do. The next slide, please. So I've introduced what an Anton pillar is. There's a knock on the door. There's a group of people there. There may be a camera. There may be a police officer, not to search the home or the business, but to keep the peace. The order says on pain of contempt, and people go to jail for contempt, you must allow access, you must allow the search, you must cooperate, you must provide your device, you must provide the passwords to the device, you must provide the charging cable, you must provide, et cetera, et cetera, et cetera. These are extraordinary remedies for extraordinary cases. There must be very serious misconduct, right? A very serious breach of fiduciary duties. Fraud is a classic example. Theft of trade secrets. These are obtained what we call ex parte. That means there's no notice. That is an extraordinary departure from our normal system. Normally, when I go to court, the other side's lawyer's there. If I'm going ex parte, the other side's not there, which puts tremendous obligations on the moving party, on the plaintiff. Right? You have to not just explain your good evidence, you have to explain your bad evidence. You have to really explain the other side's case too. Right? You have a duty to make full and fair and frank disclosure to the court. You only obtain these things for a maximum of 10 days. You know with moral certainty you're going to be back in court. You know the other side is going to challenge how the order was obtained. You know the other side is going to challenge how the order was enforced. So these are high stress, high reward, high risk. And they're on the basis that this is not to get a head start on the discovery process. This is intended to preserve evidence that otherwise is likely to be destroyed. And the best typical way to show that you think the evidence will be destroyed if you gave notice is look at the misconduct of the defendant. Right? So this is the type of person who will destroy the evidence. Why do we say they're that type of person? Look at how they stole it. Look at the misconduct, look at the fraud, you have to have a very strong evidentiary basis. And then there are all kinds of procedural protections for the defendant who doesn't know you're coming until the knock on the door. Independent supervising solicitor, you have to assume you're going to be imaging and seizing privileged communications, so you obviously shouldn't be reading those. And there's, as with any injunction, an undertaking as to damages. The plaintiff, the moving party, promises to the court that at the end of the dispute, at the end of a trial, perhaps 2 years later, if it appears that order should not have been granted, the plaintiff promising to the court to make the defendant whole. That's not just costs, that's real damages. The person may be without their devices, unable to conduct business. You may unintentionally cause severe harm to the defendant. The plaintiff's promising to make them whole if, God forbid, it shouldn't have been obtained. So a question I've often been asked by judges when obtaining this is, in effect, are you sure you want this? And the only good answer, of course, is we're not here because we just feel like it. Right? You do it when you have to. You don't do it when you think, hey, this is a neat remedy that Berkley's familiar with. Why don't we just start all our disputes with an Anton Pillar? Don't do that. It's not for that type of situation. But it is an extraordinary remedy for an extraordinary case. It's a very, very powerful tool in the litigation toolbox. The next slide, please. So I've commented briefly on Mareva. Mareva is a freezing order. Again, there has to be a real risk that the assets are going to be unavailable, classically because they're about to leave the country. Again, often the best evidence that this is the kind of defendant who's going to improperly dissipate or hide assets is the underlying misconduct. As with an Anton Pillar, they're typically ex parte, so the other side's not there. You therefore have all of those extraordinary obligations to make full, fair, frank disclosure. They're 10 days. You know with moral certainty you're going to be back in front of the court defending how you obtained it, the evidence you used to obtain it. And again, there's an undertaking as to damages. And reflect for a moment on that undertaking as to damages. You're promising to make the defendant whole. You've frozen their bank accounts. If it's a business, you may well have unintentionally bankrupted that business. They're unable to pay their suppliers. They're unable to pay their employees. You've frozen their bank accounts. So there's a very high likelihood that you've caused severe harm. You better be morally certain that you're going to be found to be in the right at the end of the day. So again, an extraordinary remedy for extraordinary cases. Next slide, please.
Berkley, just before we move on,
Yeah,
I wonder if we might invite Joe into the discussion at this point to give us his comments on just the remedies you've reviewed, because when you talk about going to court and being certain, you need someone like Joe, and I know Joe's got lots of experience marshalling that evidence.
Yeah, thanks, Jen. Certainly, and we've dealt with this sort of throughout this presentation, the preservation of evidence is key, whether it's internal to an organization at the onset of an investigation, or whether it's the preservation of evidence that's occurring as an Anton Pillar is being executed. It's that proper preservation that is certainly key in any remedy. When we're collecting evidence, especially electronic evidence, this is evidence that is easily destroyed. It's evidence that's easily changed. It needs to be collected properly. It needs to be collected by the right professional that knows how to collect it properly. Sometimes that's internal IT. Sometimes it's not. The way I typically put it to clients that are going through this sort of crisis is this a situation where you potentially want your director of IT to have to swear to an affidavit as to how the evidence was collected? And if the answer to that is no, then you need to bring in an outsider. There's certainly types of evidence that can be collected internally, but often there's a need to bring in an outsider, especially during an Anton Pillar order execution. It's paramount that the folks that are executing the Anton Pillar, so to Berkley's point, the folks that are knocking on the door, have experience in preserving that scene, preserving that site, understanding that, if this is a residence, for example, you're walking into a multi-roomed unit, and there's a process, and there's a correct process in mapping out that particular residence. There's a correct process in how we're obtaining the evidence, how we're documenting, how we're preserving the evidence, so that at some point it can be testified to. So the preservation piece is key, and making sure that's done properly it needs to be top of mind. One other point I'll add before we go on, as far as preservation of evidence, electronic evidence can also be very temporary. And this is something that I see many clients grapple with. If there's an internal component to an investigation and we need to collect emails, we need to collect logs that show when somebody's accessing certain data, what they're doing with certain data. Are they pulling data down into a USB device? Are they sending data to a Dropbox location? There are footprints that are left when any data is moved. And those footprints are very, very powerful pieces of evidence, but they're also very temporary. Some logs, whether it's through email, whether it's through just the movement of data across a network, some logs may disappear within days. Could be 2 days, could be 7 days, could be 3 months. But if you're starting an investigation 2 weeks after the fact, then those logs that would have shown you those footprints and would have given you a really good sense on how that data moved, they could be gone. So the preservation is key, and getting your arms wrapped around the data that you need to preserve quickly and understanding the breadth of your investigation is also key.
Joe's made some very, very important points. I want to re-emphasize two of them with a couple of additional comments. One of the key reasons to obtain external computer forensic support is not just the expertise, which is obviously essential in Anton Pillar, but even in a mere investigation. If you don't know who the bad guy is, you don't know who to trust internally. I'm not trying to be paranoid, but one of the ways I've articulated this to clients is to say, okay, you're a robust large organization. You've got all kinds of internal IT resources. Maybe they're even good at obtaining the necessary electronic evidence. Are you certain none of those people are friends with or involved with the source of your problem? And if you're not sure who the source of your problem is, and I have had a case where it was the former head of computer security for the client that was the bad guy. And we Anton Pillared him and we tracked him down and he was the problem. Well, he wasn't still on site, but he certainly had trained the people who would have been doing the investigation. So it's very important to obtain good, experienced, high qualified external advice. I think Joe's made a very, very important point. The other comment he made about the speed at which you have to move on some of these investigations, just as your own electronic footprints may get muddied or lost with the passage of time. Remember I talked about tracking John Doe through internet service providers. It is not in the business model of internet service providers to archive this type of information for lengthy periods of time. So you may be able to track an otherwise anonymous defendant if you can move fairly quickly. If you're moving weeks and weeks, or God forbid, months later, they don't keep this data. It's a huge volume of information, and they're not in the business of archiving all of that historic information. So again, there's a real premium placed on making the right judgment calls and making them quite quickly. So very, very important points that Joe's made. I'll turn to, on this slide, misconduct via the internet. And preparing for this, I was reflecting on probably you can still misuse confidential information or commit fraud or engage in other misconduct without using a computer and without using the internet. I just haven't seen it in a lot of years. I mean, it must still happen, but it's not how it really happens anymore. Couple of classic examples. One I've touched on is anonymous disclosure. Right? Your trade secrets are all of a sudden in the social media. And the other thing that I've seen is the misuse of trade secrets to give a superficial veneer of credibility to defamatory statements. Right? Allegations that your board of directors is engaged in insider trading, allegations that your CEO is engaged in criminal misconduct, and these defamatory allegations are given this veneer of credibility by sprinkling some of your confidential information into them, right? Something that only someone inside your organization could know. And so that type of misuse of trade secrets or misuse of confidential information, typically anonymously, is another type of misconduct. So remedies, the classic remedy for that type of thing is get it off, right? Get it off. If it's on YouTube, Facebook, wherever, get it off. How do you do that? Well, court order. website hosts, as with ISPs, reputable ones will typically cooperate, but they typically, for privacy and other reasons, will require a court order. The next step is tracking down John Doe. Right? The problem with just getting it off, it's a somewhat temporary and often illusory, because it's just whack-a-mole, right? You got it off site A, it's up on site B. So I do think you've got to try and find out who did it. ISP liability in the United States, internet service providers have very robust statutory protections from suit. They don't in Canada. I think that's useful because it does encourage ISPs to cooperate, albeit with a court order. I have neither the time nor the inclination to get into a public policy debate, but the ISP liability, I would suggest to you, is more theoretical than real. You're not really suing Facebook. That's not your real adversary. You're not really suing the website host, who probably didn't even know it was there until you said, hey, it's there, please take it down. Damages are, as I've said, the classic remedy, but your John Doe, especially if it's a hacktivist or if it's somebody who's motivated by malice, they're typically impecunious. And so you've got to think about more creative remedies. And the courts have recognized that and will grant permanent injunctions, including in a defamatory context, in appropriate cases. The next slide, please. So I will conclude with some litigation risks and realities. I will reiterate that please don't start all your litigation with an Anton Pillar order and a Mareva. Right? It's not viable or sensible. These are risky. They can boomerang. The case can very quickly turn from being a case about the misconduct of the defendant. There's all kinds of Anton Pillar horror stories, thank God none are mine, where the case now all of a sudden is about the plaintiff misleading the court, the plaintiff not making full and fair disclosure, the plaintiff being overzealous in the enforcement of the Anton Pillar. All of a sudden, you're on the defensive. It's not about what the defendant did. It's about how you're litigating it. So these are, as I've said in the slide, high risk, high return kind of situations. The other reality is typically clients have never been in this situation before. You've never had a high profile breach and disclosure of your confidential information. You've never faced this type of crisis before. And you're making a lot of real-time judgment calls. So you need, to Joe's point, you need experienced external experts that have done this and that can guide you and can make sure that it's done right so that it doesn't boomerang and blow up in your face. The undertaking as to damages is a real undertaking. You're promising to the court that you're going to fix this with money if you did it wrong. So careful what you wish for. And they are expensive, right? It's a team of people. There's an independent supervising solicitor. So that's not my firm, that's somebody else. Guess who's paying for that? There's external computer forensic. You're doing coordination with probably internet service providers, banks, perhaps the websites, sometimes the police, even just to keep the peace, not for the purposes of the search, but not everybody is thrilled to have a crowd of people show up at their business or home and allow access. So there's a lot of moving parts, and they're very expensive, right? These are not for low end, oh, well, I wish he hadn't forwarded that email. Therefore, extraordinary cases, but they're very, very powerful. And then the final thought is, remember, these are all at the front end. You may be front end loading a lot of the litigation, but you're not done, right? This initial battle may be critically important. It may determine the larger war, but it's not typically the end of it. So remember, these are extraordinary first steps, but you may be in for a protracted fight, especially if you're against a well-funded adversary. Anyway, let me pause there. I know we've got lots of good hypotheticals and hopefully some questions from the audience.
I think just before we move on to the hypotheticals, I'll again invite Joe back into the discussion. Joe, I know you had a couple comments you wanted to make about the last points that Berkley wanted to raise.
Yeah, thanks, Jen. I mean, a couple of these things we've already touched on, but ensuring that confidential information that we're talking about here is cataloged. that it's given the correct level of cyber protection, falls under certainly a data governance lens. But at the end of the day, those crown jewels, your confidential information needs to be included in that. I've seen a disconnect between what the cyber team is doing and protecting versus what the business needs protecting. Obviously, cyber is a very technical piece of an organization, but there needs to be a legal, a governance, human resources. All of these voices need to be heard when you're developing those cyber policies to make sure that it's not just infrastructure that's being protected, it's crown jewels data that's being protected as well. Also, proper cataloging will help you identify risk in the event of a breach. Does the exfiltration of data in one segment of your infrastructure, does that become a reportable breach? Was there personally identifiable information, for example, that was exfiltrated in a breach? Understanding your data, understanding where your data resides, cataloging it properly will help you in a crisis identify what your risk level is. With each breach, there is certainly a reputational risk and litigation risks, but understanding what data has left the organization, if data has left, is paramount and key to understanding where your risks lie and your risk level. And again, it comes down to, the preservation, being able to understand what data is left, if it has indeed left in a breach, identifying that data, but preserving the artifacts that show what data left, so that if you do need to report it, that you've got some evidence to back that report up.
All right.
Thanks, Jen.
I'm just going to pick up on a point that I think Berkley raised, or it may have been you, Joe, but when you're trying to decide whether or not to use your own people to collect the information, certainly there's the concerns Berkley raised about not knowing perhaps who's committed the breach and the fact that you may be asking the fox to guard the hen house. But also there's the issue of, if this can't be resolved and it ends up in court, as a litigator, I'm always looking at, well, who's going to be in the best position to, to be cross-examined on an affidavit or to explain to a court what they seized and why. And that's, and you may have the right people internally who have that sophistication, who can do that. But that's certainly something you're going to think about when you're deciding who's going to collect the information, because you can't have one party collect it all and then, put somebody else in court to explain the collection process. And, you may try, but it gets a bit messy. So just another factor to take into account.
Yeah, and I think too, sometimes the independence of a third party is important to keep in mind as well.
Yeah. I also want to pick up on something that Alix raised. So Alix was talking about, this important point about expiry dates and employment agreements. And I think that just coming back to that, if this information truly is a trade secret, picking up on the issues that Jason raised, 2 years isn't going to be enough to preserve the secret recipe. So Alix, just come back to you on the non-disclosure agreements and whether or not you can actually have an unlimited provision in your non-disclosure agreement that would address something like this, or do you have to have a sunset clause, or can you try to have it go on forever and ever?
Jen, that's a great question. So, typically I'm drafting employment agreements, sometimes non-disclosure agreements, but Jason can jump in on that piece. And I would say that I always say that confidential information must be maintained for all times during the employment relationship and after the employment relationship ends, for whatever reason, be it the person's terminated for cause, without cause, or resigns. So absolutely, you want to maintain that. It can last for a much longer period than 2 years, which ensures that you can protect it unless it obviously becomes part of the public disclosure in the normal course. Not sure, Jason might have a couple of points to jump in as well.
Well, the same is true in non-disclosure agreements in commercial transactions long before litigation arises. If you have a business that depends on trade secrets and you are proposing to sell it to an interested third party, you will put in place a non-disclosure agreement, and it will say that you will keep the confidential information, and in particular the trade secrets, confidential forever. And unless the prospective purchaser is prepared to give you that relief, they're prepared to agree that they won't disclose it forever, I would be very reluctant to enter into that transaction, because you will lose the value in your trade secret the minute it becomes public information. And likewise, if you're acting for the purchaser and somebody presents you with an agreement that says you promise to never disclose our trade secrets forever, you would want to know pretty clearly what kind of trade secret information are you going to give me? Because the worst thing in the world is to agree that you'll never disclose something, and then when you finally learn it, you realize it wasn't a trade secret to begin with. It was something that was so obvious or already so well known that you would never have agreed to this provision. So in that kind of circumstance, you want some mechanism that allows you to contest whether the information was in fact a trade secret. And those kind of provisions exist in IP litigation as well, where as a matter of course, the federal court will issue protective orders saying that you will not disclose confidential information that's revealed to you during litigation, and confidential information includes trade secrets, and typically there is no sunset provision in those agreements. So you just have to be very careful about what you're exchanging, keeping close tabs on what you've given out, what you've received from other people, and to make sure in advance that you're actually turning your mind to whether or not you can abide by a forever type clause.
All right, so I should have said this at the outset, but if anyone has any questions, please use the Q&A function to type your questions in, and they will be relayed to the panel. But I think what we could do now, panelists, is turn to the hypotheticals, and I'm going to just review them very briefly, and then I'll invite people to provide their comments. And what we're going to try to do here is to really provide people with practical advice. So the first one is an anonymous email that lists all of your employees' salaries is sent to your employees. I've actually seen this happen. So why don't I start with you, Berkley? Have you seen this happen?
Yeah, I've had this. It's a very frustrating situation for an employer to have, the junior staff know what the senior staff make. Everybody knows everything. In the case I had, it initially seemed that the anonymous email had been sent from within the organization. It had been sent from literally the plant floor. So step one, robust computer forensic investigation, which made it clear that no, in fact, that was a false, somebody had tried to cover their track, and it had actually come from outside the organization, and it had merely been made to look like it had come from inside. And so step one was in Norwich. Let's try and track. And I was pleasantly surprised. We were able to track it to an IP address that was used, and I won't bore you with the intricacies of how IP addresses work, but among other people, it was used by the former head of the computer and security department at that plant. And we then obtained an Anton Pillar order, and sure enough, we're able to get pretty robust evidence indicating that he, largely for malicious reasons, had been disseminating this. But a couple of sad comments. So, easy for me to say, well, that's a win, right? We got what we wanted. But, and this is an unfortunate reality of trade secrets litigation, you can't unring the bell, right? We can't wash the memory of that email from the employees' minds, right? So this highlights, my remedies toolbox is wonderful, but boy, spend your pennies of prevention on Alix, and trying to avoid the problem, and having that salary information perhaps should have been better protected, right? Is it the crown jewels? So when you can, spend your money on Alix and people like Alix and Joe and people like Joe, and query whether that quote unquote remedy, right? Damages were illusory, right? What damages would have solved the problem? So it's a good example. I would suggest to you that fixing a breach may not erase it.
It strikes me that's probably also applicable to the second hypothetical here, in that the profit margins for each of your customers' recent orders are posted online. Obviously not information that you want disclosed publicly. Any comments from any of the panelists on that situation and what you might first steps might be to address something like that? Berkley?
This is a little different because it's public. The first step is get it down. I mean, and Joe, I welcome you. A good computer forensic investigation is obviously essential, but this one, you can't unring the bell, but get it off. Like, I think step one, even while you're doing the investigation, get it off.
Yeah, I agree with that. Stop the bleeding, right?
Yeah, and how do you do that practically?
Give me a call and we'll try and obtain a court order as quickly as possible. Right? We don't know who the defendant is. It's a John Doe type of proceeding, and your remedy in first instance is against the website host, who's we've said is posted online. That person hopefully will recognize that this type of information, profit margins, hey, that's not what my website's for. It looks confidential. Might they voluntarily remove it with an appropriately worded demand letter? Maybe, but they may say, go convince a judge and I'll do whatever the judge says. So it's run up the street back when we ran up the street to court, or now get a judge and get an order that it be removed. That at least stops, as Joe says, stops the bleeding. Meanwhile, do an investigation. How did it get there?
So Alix, a key employee quits to join a competitor, and the competitor starts to target your key customers with prices slightly lower than yours. Slightly lower. So you've got a suspicion that something might be going on here. How do you get the proof?
Well, where there's smoke, there's usually fire. But, obviously you want to understand what contractual obligations may exist. So as I mentioned before, exit interviews, communicating with the employee as they're departing to remind them of their obligations is really important. And then obviously, understanding whether or not that information was downloaded from your system and that employee has access to that information, that's going to be key to connecting the information that's being used with what actions are being taken by the former employee at the competitor. Obviously, you want to impact that employee as quickly as possible if you think that they're using information, and obviously, trying to outbid you with lower prices is to, make sure that the employer that they've gone to understands that they have post employment obligations, both with respect to confidential information, but potentially, obviously, with non-solicitation of customers and clients. So again, making sure you act quickly to advise that person, and then taking whatever litigation, and Berkley can jump in on that, to try and connect that information to the actions of the employee. And with the employer, you're obviously saying they're inducing breach of contract. So, you can, often these litigations will include the competitor employer in the litigation through that inducement, and making sure that they're aware that the employee has those obligations is key at the beginning of that litigation. Berkley, not sure. I think you've dealt with this situation with me a number of times.
Yeah, no, I agree with everything Alix said, and I would say, as much as I'm happy to litigate these, an option, and step one is to just beat them in the marketplace. Right? You don't have to sue. Do you fight it in the marketplace? If you don't fight it in the marketplace, do you just sue? Seek damages, have a trial in a couple of years? Do you seek some sort of injunctive relief? And then a point Alix has made, who's my real adversary here? Is it the ex-employee? Is it his new or her new employer? Who am I suing and what do I want? And depending on how good your computer forensic evidence is, do I want or need an injunction? And what is the injunction? Right? I'm not going to enjoin the competitor from competing. Am I going to enjoin some solicitation? I think this is a good one for, what's the right remedy? And there isn't always an easy answer to that. And one of the answers, difficult though it may be don't do anything. Do your cost benefit analysis and fight it out in the marketplace. How badly are you being hurt, and what's your risk reward?
Well, it strikes me one too, though. You may have a suspicion. So one of the things you might want to do, Joe,
Yeah.
is get someone in to look at the employees' trail to see did they download anything before they left.
Yeah, I mean, one of the best pieces of advice I can give on something like this is there's a method of preservation that doesn't cost anything, and that is don't be quick to recycle an employee's laptop. Don't be quick to get rid of an employee's mailbox. Give yourself a month, give yourself 2 months, give yourself 6 months if they're a key employee. The mistake I see more often than not is key employee leaves. 3 days later, the laptop is wiped or even just reformatted and given to another employee. We're losing evidence by that happening. We don't lose any evidence if I walk out the door, I hand in my laptop's put in somebody's drawer, or even better, thrown in a company safe or something like that, and just maintained and preserved. Because the reality is, I can look at that laptop 3 years from now, and nothing will have changed. The evidence will still be there. But if we recycle the devices quickly, and I understand there's a cost benefit to that, but if we recycle an asset quickly, we are losing evidence. So my advice to clients is, if this is a key employee and there's even the slightest hint of suspicion, it doesn't cost you anything just to keep that laptop powered off. Don't let your IT folks poke around, because by poking around, you're changing evidence and you're even deleting some evidence, getting rid of some evidence. Just close that laptop, preserve that mail account, and be patient, because you'll be able to look at that evidence later.
Let's go to the next slide. We've got time for a few more hypotheticals. So the fake customers on your confidential customer list start getting email solicitations from a rival business. So Alix, the assumption here is that you actually have fake customers on your confidential customer list. Is that something you've seen people do?
I mean, I think, I haven't actually experienced this. I think Berkley's experienced this, where, you deliberately create a fake customer list, and when you start to see it coming up in the marketplace, it's being used by a former employee who's accessed your customer list. And obviously that can create some evidentiary trail that they're misusing confidential business information. Berkley, I think you had a specific example of this happening. I'm curious to see what happened in the situation and how you dealt with it.
Yeah, no, this is a hypothetical based on quite a sophisticated client, and they had quite a robust computer security department. One of the things they did on a regular basis, they would seed their own customer list with fake customers. And then they could tell if a solicitation happened. And let me back up. One of the key trade secrets in this customer's business was the customer list. And one of the key values was they knew that us soliciting that customer list periodically, carefully, maybe just once a year, was very valuable. That's how they grew their business. In contrast, they knew that if that list got out and was spammed, people would just stop using those emails. They weren't going to be interested. So the value of the list was to not use it very often. So by periodically, I think quarterly, they'd add a new one so that they would know immediately if an alarm bell went off. Hey, fake account from 2019 just went off. And they'd be able to identify, well, who had access to that list at that time? And sure enough, it gave us some leads as to where do we think this is coming from. And it led to, there was actually a group of ex-employees in multiple provinces, and we Anton-pillared them simultaneously in multiple locations. But it's a good tip. So if your customer list is one of your trade secrets, if that's of real value to you, And not every business will be like that, right? There may be a business where you say, look, everybody knows who the customers are. The old joke is you can go to the yellow pages and have a list of my customers, right? I sell rolled steel bars. There's only so many people who buy that, and everybody knows who they are. But if your customer list is one of your valuable pieces of confidential information, it's an interesting idea, right? Somebody spamming your list isn't going to know that this is a fake customer, and you're immediately going to be notified that your secret is out, and you can take steps to try and recover it and protect it. A final thought: this was a sad one because although we put a stop to it, the unfortunate reality was these people sold the list to competitors and spammed it, and they sold it for a very nominal amount of money compared to the significant value that it had for the client. So obviously we needed a large judgment, which they were not able to pay. This is the fellow who said, you've ruined my life in Canada.
So the next hypothetical deals with ransomware. An anonymous email to your CEO threatens to publish your customer's personal information unless a Bitcoin ransom is paid. Becoming more and more common, Joe, as I understand it. I think at one point this may have been an outlier, but it's not so much anymore. Perhaps you could speak to your experiences with this in the current environment.
Yeah, ransomware is a very interesting one. 5 years ago, it was a nuisance attack. You could either recover from backup and ignore the ransom request, or you pay the ransom to get the key to decrypt your data. But now bad actors are exfiltrating data along with encrypting data. So I see an example like this, and the first thing I think of is on the investigative side. Do you have logs that show, one, the data was exfiltrated? Do you have proof of life from the anonymous email? Has the emailer attached some of your confidential information to prove that they've got it? And then there comes, the question is, do you pay or do you not? If you know for a fact that the bad actor does have your customer's personal information, the question becomes, is that information such that we need to pay to, at some level, ensure, and I'm using air quotes, that that data is never published? And if we do pay, is there any guarantee that that data isn't published? It's a very complicated and complex question, whether to pay the ransom or whether not to pay the ransom. And there's, in the US, for example, there's actually, there can be legal ramifications to negotiating and paying ransom.
In the sense, Joe, that I take it it's not legal in all jurisdictions to make that payment, that if you make it, you may find yourself in trouble for having made the ransom payment.
Yep, that's correct. There's fairly recent changes in the U.S., for example, that there is a list of individuals, bad actors, known bad actors, that if you negotiate and pay them ransom, there will be sanctions against your organization. Because typically the reality is, it's as much as these, I'm going to use air quotes again, as much of these ransomware attacks, the attackers try to make them appear legitimate. It is crime. And oftentimes the larger bad actors are members of organized crime and state-sponsored organized crime. And the funds that are being paid to them are used for terrorism, used to perpetrate other crimes. So there's a real moral question on whether to pay or not to pay as well. But it's also a business decision.
So one of the questions that we've had come in is about breaches that span multiple legal jurisdictions, and how do you start to address an issue like that without any of the specifics. But I take it, Berkley, Joe, you've got to have quite a big team in order to try and get your arms around something like this.
Yeah, especially if we're talking multinational And we've seen attacks and breaches that have hit organizations in a bunch of different countries in a bunch of different jurisdictions. The reality is, if there's an investigation, you want that investigation to be as thorough as possible, but also conducted by hopefully one single firm that is doing things in the same manner, independent of where the jurisdiction is. I'll let Berkley speak to the legal side of that, but certainly from an investigative side, it's important to have sort of the same approach no matter where, no matter what country the organization happens to reside in.
Yeah, the legal side is problematic because, to make the trade observation, law is a jurisdictional based, so Ontario remedies may not be effective in some jurisdictions, and some jurisdictions, the remedies may not exist. Like things like the Anton Pillar, it's not uniquely Canadian. It arises out of England, but the Americans really don't have an equivalent remedy. So the jurisdictional realities can be very legally challenging. In addition to the practical ones, I'll use the hypothetical here of that Bitcoin ransom. This is probably, and where there's a large interjurisdictional one, it may be one of those rare cases where you're able to obtain some police, governmental, RCMP, CSIS support because of the reason Joe identified. Some of these are, and unfortunately had this situation, are terrorism financing or organized crime. And that, unlike your vanilla departing employee, critically important though that may be, and some of those may be of existential importance, the police, their resources are very limited, and they're not going to help you with what is regarded as a civil dispute. In contrast, where you have a very large organized crime or terrorism financing angle, it may be the appropriate type of case to try and get help. You may not get as much help as you think you ought to get, but it's those types of cases where you may actually be able to obtain some assistance from law enforcement or other government agencies. But the reality of the internet, it's instantaneous and it's worldwide. So some of these attacks are not originating in Canada, although I'm constantly surprised when we do track down John Doe, and sure enough, it's somebody sitting in Montreal.
Some 17-year-old sitting in Montreal.
Yeah, they're not all sophisticated government actors. Let's put it that way. But if you unfortunately are the subject of one of those types of attacks, get as much help as you can and get it as soon as you can. And to Joe's point, get it from somebody who's dealt with this before. These are not fun cases to sort of dabble in. And God forbid somebody says, "Oh, an Anton Pillar, I've never done one of those. I've always wanted to do one. I'd love to learn on this one." These are the stakes are too high to be just sort of trying to do it yourself off your own desk sitting at home under COVID.
All right, I see we're at time. So with that, I think we will skip the last two hypotheticals and thank everybody out there for joining us. We do look forward to the point in time when we can have you back into our offices, and we miss seeing our clients and all of you. So hopefully we can continue this discussion next time in person. And a special thanks to Joe for joining us today. We really appreciate your insight. You are a very valued part of any of these litigation efforts. So thank you so much. Thank you, everyone. Bye now.